So Jeff and Nancy, we've covered a lot of ground today. We've talked about everything from your retirement plan to education funding for the kids. Jeff, we talked about the transitioning of your business. We've even talked about life insurance and investments. So I think the final area for us to cover today is estate planning. And most people, when they think of estate planning, think of it in terms of two areas. One is either the reduction of estate taxes, or the other is distribution of assets. And while it's true, a properly executed plan can help with both of those, there are other areas in which an estate plan can benefit a family during both lifetime as well as incapacity. Unfortunately, people oftentimes don't think an estate plan is for them. And there's a couple primary reasons why that's so. The first is when people think of it in terms of assisting with reduction of estate taxes, with the estate tax and gift tax exclusion amount at $5.4 million, most people's estates fall below that threshold, so they don't think of estate planning benefiting them in any way. It's not going to help to reduce taxes, so why would I need an estate plan? Well, the reality is that an estate plan can also manage your affairs and your assets during your lifetime. It can sometimes help with protection from creditors and lawsuits. It can help protect the financial interests of minor children, not only from creditors and predators, but also from themselves. And it can also help with the administration of your estate, as well as the potential reduction in costs of administering your estate. Another reason that people oftentimes don't think that an estate plan is for them is the cost that's involved. And while it's true that some estate plans, very complex ones, can run tens of thousands of dollars, a more basic plan, one that I would recommend for the two of you, is much less expensive. And when you think about the potential savings as well as the peace of mind that having an estate plan would provide, I think the cost is really justified. Another reason that people don't think about estate planning for themselves or are concerned about estate planning is the permanency of the plan. A lot of people think that what they put in place today can't be changed tomorrow. And so they're reluctant to do something today, not knowing what the future holds. Well, the reality is there are a number of documents that allow for flexibility inside your estate plan, things that don't take effect really until the time of your passing. So the idea of being concerned about permanency, doing something today that you can't change tomorrow, if done properly, it shouldn't be a concern for most people. The last obstacle to drafting and implementing an estate plan is the time that it takes. Now, the good news is that you too have already done the lion's share of the work just by completing the financial planning process. A lot of what we did inside the financial planning process will help dictate the recommendations and the documents that I would recommend for the estate plan. So while there's still some work that needs to be done, most of the time-consuming piece is already taken care of. So let's talk about what you currently have, and let's talk about what I would recommend. You both shared that you currently have simple wills in place. And from what I've gathered from our conversation, it sounds like these wills were probably drafted some time ago and probably before you adopted Jeff Jr. and Emma. So my concern with those documents is that they're really not reflective of your current situation, nor do they probably provide for the needs of your minor children. Now, wills do serve a purpose. They basically can set forth some basic parameters around how your estate should be handled at your passing. They can also be used to name your executor as well as guardians for your children, which is incredibly important because, again, if you don't specifically name your executor or guardian for your minor children, the probate courts will do it for you. And there's no guarantee that they would have chosen or will choose someone that you would approve of. So it's really important that in your will, you make very specific designations as to who you want to handle your estate as well as care for your minor children. Wills can also be used to make bequests as well as distribute assets. Unfortunately, any asset that passes through a will or is distributed through a will also pass through probate. And probate is something that I find most of my clients want to avoid. And there's a couple of reasons for this. One, probate is a public process. That means anyone can go down to the courthouse and they can look up information on your estate plan. And a lot of my clients are very uncomfortable about that thought. The other reason that clients like to avoid probate is the cost. There's additional administrative costs with going through probate, and any assets that you can pull out of the probate process will create cost savings for you. The last piece about probate is it can be a lengthy process. So by having a properly executed estate plan in place, you can reduce some of the delays that you could experience in administering your estate and closing out your estate. So one of the documents that I would recommend for you is a will. As I said, it's kind of the beginning foundation piece of an estate plan. However, the will shouldn't be your entire estate plan. I would pair your will with something called a revocable living trust, which is basically a flexible document that would hold assets during your lifetime, help you manage assets during your lifetime. You would have complete control over those assets, but at the time of your death, the trust then would become irrevocable, and the terms of the trust would be what you dictated as far as how you want your assets to be managed for your family. Additionally, within the will, I would include something called a pour-over provision. The pour-over provision is basically wording inside the will, that says, should you miss any asset, something that's not titled in the revocable living trust, this pour-over provision would take those assets and make sure that they poured over into the revocable trust. So it's basically like a safety net. It makes sure that nothing is missed during the administration process of your estate. Lastly, in addition to your will and the revocable trusts, I would also suggest that you both draft documents that speak for you when you can't. So these would include things like a financial power of attorney, a durable financial power of attorney, a durable healthcare power of attorney, as well as a healthcare directive or living will. You'll notice that I used the word durable on several of those documents, and that's something that's pretty critical. A durable power of attorney, whether it be healthcare or financial, that wording in there ensures that even in the event of incapacity, mental incapacity, those documents will still be in full force and effect. So you want to make sure to have that durable language included. Now, with the financial power of attorney, that's basically a document that provides for who can oversee your financial affairs in the event that you can't. And the you can't piece can be anything as simple as you're on an extended vacation and out of the country. It could be that perhaps you're suffering from a long illness and you want someone to be able to go to the bank on your behalf. Or it could be in the event that you become mentally incapacitated through dementia or other means. So basically it outlines who can make decisions on your behalf. The healthcare power of attorney is very similar to a financial power of attorney, except it speaks to healthcare decisions. So again, in the event that you can't make decisions for yourself, and this could be something as simple as you're under sedation for surgery and a medical decision needs to be made, or again, that long-term illness, coma, or mental incapacity, the person that you designate could then step in on your behalf and make medical decisions for you. The last document that I mentioned was that living will. This particular document deals with end-of-life decisions. So it's everything from who can make decisions around when to maintain life support, when to discontinue life support, how you want your final affairs to be handled, whether it be through burial or cremation. Basically, this document speaks for you. And the other thing that this document does achieve is peace of mind. When this document springs into effect, it's typically during a time of emotional hardship on the family. Usually the family is agonizing and really struggling with some very difficult decisions. By having this document in place, you've already made those decisions for them and allowed the family to really address these areas in a way that you would want them addressed and make the decisions that you would want. The other item that I would consider for your specific situation is an irrevocable life insurance trust. We talked about increasing your life insurance coverage to about $2 million each. And with that level of potential benefit, it would make sense to establish an irrevocable life insurance trust that, if executed properly, would guarantee that those assets are removed from your estate. And it would also guarantee, through the terms of the trust, how you want those benefits handled. In other words, who would benefit from those assets and how. I think that's really important for a couple of reasons. First of all, you have an extended family. Jeff, you've been married before, and you have 2 children from that marriage, and you would want to make sure through a trust document that those children are taken care of in the way you'd want them to be taken care of. Typically, with estate sizes that your family would have, at the first passing, all of the assets would transfer to the surviving spouse so that she can maintain her lifestyle and care for the minor children. Well, if that were to happen, there is a chance, not perhaps intentionally on Nancy's part, there's a chance, though, that no assets would be left over after Nancy's care and the care for the children and the paying of education expenses. There'd be nothing left over for Ashley and Ryan. On the flip side, for Nancy, you might want to ensure that the assets from your life insurance policy really benefit just Jeff, Jeff Jr., and Emma, or maybe a smaller percentage were to go to Ryan and Ashley. Again, the trust document could spell that out specifically to make sure that your children, Jeff, are taken care of, and Nancy, your assets are handled in the way you'd want them to be handled as well. One other thought, as I think about your situation, Jeff, is coordination. You're going to want to work closely with Susan as best you can to coordinate your plans with hers, especially as it relates to the care of Ashley when she's a minor. Ryan, because he's of legal age, he doesn't need to be concerned about guardianship or anything like that, but Ashley would. So you two will probably want to get together and talk about if something were to happen to both of you, who you would elect to be a guardian for Ashley. One other thought on guardianship for both of you is I think of guardianship as two separate phases. One is the guardianship of the body or the guardianship of the children. Who's going to take care of them on a day-to-day basis? Who's going to provide a home for them? The second is the guardianship of the finances. So in other words, who's going to make the financial decisions on behalf of the children? And I found in dealing with a number of my clients that the guardian of the children and the guardian of the finances should be two separate people. I would leave the guardianship of the children, the one that takes care of them, be the one that can provide them that loving environment and not be the one who also has to potentially say no to them. I also think about, I've seen situations where guardians have been put into very difficult situations, emotional situations, under which poor financial decisions are made. So I oftentimes recommend for families that the guardian of the finances be a non-family member, a non-friend, and typically I would recommend a corporate trustee, a law firm or bank to take over that responsibility. They're in the business of handling finances. It's what they do for a living. I would say it's a good choice to select someone like a corporate trustee to handle the finances for the kids. Lastly, as I think about this, is